contract of agency is a species of general contract act what we have discussed in the first and the second unit. So that in that last first and second unit we studied the what is the basic essentials of a valid contract. So being a species of this contract act, this is a special form of contract called as contract of agency. So it is also a form of commercial aspect wherein we have a small business to large and unlimited business we have every day we have entered into. Knowingly or unknowingly we are always entered into a business, maybe implied or maybe by express or through an agreement. In such cases, if one man enters into a business transaction with various persons in various places, he cannot himself contract into the business with everybody personally. In such cases, it is necessary to appoint some persons to act on his behalf. So, this contract of agency deals with when a person appoint any person to work for himself. So, what are the legal consequences that we have to study in this unit? This is the unit 4 in block 1 of the first semester of MBA. So, this contract of agency is nothing but a person who has been appointed as an agent by the principal to act on behalf of the principal called an agent, and hence the definition who can be called as an agent is an agent employed to do any act to another or to represent another in dealing with third parties. That means that agent is a middleman who acts for the principal in dealing with the business transaction with the third persons. So he is an agent, he binds the principal for all the works and dealing with the transaction with the third parties. So example, master and the servant and employer and the employee. Employer gives so much of work to the employee for represent on his behalf to do any act to with a third person. So the person for whom such act is done is or who is so represented is called as a principal. So the principal always appoints someone to act on his behalf is an agent. So hence the agent is a connecting link between the principal and the third party and the liability of the agent. So whatever the act done by the agent, it has been done by the deemed to be done by the principal himself. So he binds the principal and the third person. So how an agency, contract of agency is said to be created, or what are the essentials of contract of agency? Here I have already said all the basic needs are essential of a valid contract or the general principle of contract must be complied with. First thing, the principal must be competent. Competency of contract means he must be a major and he must be not of unsound mind. Competent person can appoint a person as an agent and then who attains the age of majority and of sound mind. He can appoint any person as an agent. And who can be an agent? That any person, even a minor, can also be an agent. And no consideration necessary in the contract of agency, because it is a basic principle of valid contract is no consideration, no contract. This contract of agency is an exception to this basic principles, that is no consideration necessary in case of a contract act or in case of agency. So there are several types of contracts, because every day every people enter into various type of transaction, and hence there are several types of contracts. One is a general agent. General agent is a person who is employed to do all acts connected to a particular transaction. So in a sale of goods, in selling the goods, he is selling the goods. So whatever the things necessary to sell the goods, he can do all such acts to do a particular act with respect to business or employment. Example, if a manager of a firm, whatever the business of the firm, the manager can do whatever the acts with respect to that particular transaction. Similarly, special agent. Special agent is a person who is employed to do some particular act. Transaction may be anything, but particular act and represent principal in some particular transaction. Say for example, in realizing a check, that is a particular transaction. So any person is employed to do that, he is called as an agent. And then universal agent. Universal agent is a person who has an unlimited authority. He can do all the acts which may be entrusted to the agent by the principal. And also, according to the nature of the work, these agencies also can be created. Say for example, mercantile agent. Mercantile, then in ordinary usage, in ordinary term, we say in the case of business, any sale or any purchase, the person is called a mercantile agent. So in case of a mercantile agent, he has the authority to sell the goods as well as buy the goods, or he can raise the money on the security of the goods. Suppose if the principal has kept some goods in the custody of the agent or in the custody of any person, in such cases, in raising money on the security of goods also, that mercantile agent can be done. There are various kinds of mercantile agents with dealing with other aspects. One is a factor. So only the person who is entrusted for sale of goods. In case of sale, the person is called as a factor. And the commission agent. Commission agent is one who in dealing with the sale or purchase of the goods and on a commission basis, he is called as a commission agent. He may pledge the goods also. Means mercantile agent is having all the powers to deal with the third parties for the best of the principal. Whatever is the advantage to the principal, such acts can be done by a commission agent. Next, del creditor agent. Del creditor agent is a person who acts for extra commission. So hence his responsibility is also more. He is more responsible for act of the principal towards the third parties. Then broker. Broker is nothing but a middleman. He is not having any possession of the goods. Only thing, he can make a connection between the principal as well as a agent, or he can bargain with respect to any transaction. Then non-mercantile agent, he is not dealing with any sale or purchase of any property, but only it is a non-business such as advocacy, or it may be a insurance. So advocate is also considered to be an agent. He is an agent with respect to his client, and he is representing in dealing with the court. Similarly, insurance agent. He is a middleman with respect to insurance and the third parties. And next is the creation of agency. How a principal can appoint an agent to do his business. First by actual authority. By actual authority means it may be by express through the words or maybe in writing agreement. Normally all the business transaction with respect to contract of agency is maybe in writing by an agreement. It's a deed of agreement. The agency can be created, or by giving a power of attorney. Power of attorney also, it may be a general power of attorney or it may be a special power of attorney. And secondly, by implied agency. So sometimes an act of a person makes the principal to be liable for that particular act. It is by implied authority or by conduct of the principal makes the other person to believe that he is an agent. And also by rule of estoppel. Rule of estoppel is such that sometimes the principal creates an impression to the third party that a person, though he is not an agent to the principal, but make the third person to believe that he is an agent. Actually he is not. In such cases, that is called rule of estoppel. So if a third party believed that he may be or he might be an agent of the principal and acted on that particular basis in good faith, in such cases the principal cannot deny it that he is not an agent. So whatever the act done by the agent binds the principal. Similarly, by doctrine of holding out. Holding out is nothing but in the case of estoppel, rule of estoppel, principal will act it towards the third party as if any person is an agent. But in case of holding out, any person, not an agent of a principal, makes the third party to believe that he is an agent to the principal, and based on that the third party enters into a business transaction. In such cases, third party, if he acted in good faith, then though that person is not an agent, he binds the principal. But in order to make this rule, some affirmative act with the principal to necessary to establish the agency, contract of agency. An act of necessity. So agent, though principal need not appoint a person as an agent, but in case of emergency, where is necessary to act as an agent. Say for example, in case of a minor. So maintenance of a minor is very important. Education of a minor is important. In such case, if nobody is there, some guardian or some third person will look after the necessaries of the minor. In such cases, he is bound by the contract of agency. So in such cases, agent should appoint or act in bona fide in the interest of the principal. In such cases, necessarily an act can be done by third parties binds the principal. Then agency by ratification. Ratification means subsequent adoption of a person as an agent. Act done previously, but that act was affirmed by the principal as if that act was done by him alone. It is called as ratification, means adoption of the act done by a third party subsequently. So in such case also this agency can be created. Then how an agency can be extended? So it's actual authority. Actual authority means if the principal by express words or by conduct make or appoints a person as an agent, it is an actual authority. Maybe by deed of agreement or by a power of attorney, an agent can be appointed. Ostensible or apparent authority. Apparent authority means though the person has being an agent of the principal, but he acted in excess of this actual authority. Say for example, if the seller or the principal appoint a person to sell a property for, say for example, for 10 lakhs rupees, but he sell that property for more than 10 lakh or less than 10 lakh, means whatever the authority, that agent exceeds that authority. Sometimes the principal have ratified that act, it is called as apparent authority. Then authority in case of emergency, where though the person is not an agent, but in case or being an agent, sometimes he must have been in a position to act beyond the orders of the principal. So in case of emergency also, principal is held liable for the acts of the agent. And delegation of authority. Sometimes even an agent, principal can do all the acts alone. Similarly, an agent can also do all the acts, cannot do all the acts alone. In such cases, he can appoint some other person as sub-agents. Sub-agents and also sometimes substitutory agents. But liability of a sub-agent is only to the agent, not as to the principal. Suppose if a sub-agent is appointed by taking the permission from the principal, then act of a sub-agent is deemed to be the act done by the principal. So being an agent, what is the duty of an agent? To do work for the principal, or while doing work for the principal, first thing is he has to conduct the business of the agency as per the direction of the principal. That is the first and foremost point to be considered, because under the actual authority, whatever the act that has been assigned to the agent, he must act those work only. An agent should act with skill and diligence. That means with using his all intelligence, the agent must act to the best of the principal. Thirdly, to render proper accounts. So whatever the transaction made by or taken by the agent must be have accounted all the transaction to the principal. And whatever the difficulty arises during that business transaction, that all must be communicated with the principal, and taking the consent or assent of the principal, the agent must move with. And not to deal his own account. That means any transaction which is benefit to the agent, that cannot be done. And also no misconduct or no loss is to be made to the principal. So no personal profit can be made by the agent. And lastly, not entitled to remuneration for misconduct. If an agent during his course of agency has done any misconduct, then he cannot get remuneration from the principal, or else whatever the act that was done by the principal agent, he will be remunerated for those acts. Similarly, what is the right of an agent? Always rights and duties are reciprocal. One is right of an agent, right to remuneration. Always whatever the act done by the agent, he will be entitled to get the remuneration. Remuneration means salary or commission, whatever the agreement there, that he is entitled to. And then right to retain. Say for example, if an agent, in case of sale, if an agent has to retain the property, or he has to incur some expenses for taking that care and custody of some product or some things or some goods, in such cases he has incurred some expenses, that expenses can be recovered from the principal, and hence right of retaining the property until payment is made by the principal, that agent is having that right. So he can have receive the amount of principal due to himself in respect of advances or expenses. Say for example, if the agent has to buy some goods, he himself has paid some advance from his pocket, that can be reimbursed from the principal. Then right of lien. Right of lien means writing or taking, putting the goods in his custody. Say for example, if the person have the remuneration has not given by the principal, or expenses has not been recovered from the principal, in such cases the agent can withhold the property until and unless the amount is paid. Then right to stoppage in transit. Suppose if the goods have been put in transportation, so it is out of hands of the agent, so he cannot exercise his right of lien. In such cases, right of stoppage in transit means he can withhold that goods in the transport itself. That means that goods cannot be delivered to the third party unless some expenses or whatever the payment is due to the agent. Then right of indemnification. Indemnification means the act must be represented as if the act of the principal himself. So in any agent act in good faith, so whatever the act done by the agent must be indemnified by the principal as if the act is done by the principal himself. So no personal liability of the agent. So act done by the agent as if the act was done by the principal. Then right to compensation of injury caused by principal's neglect. So any injury or any loss caused to the agent because of the principal negligent, then agent can recover from that amount. Similarly, duties of the principal. So duties of the principal is as of the right of the agent. Hage rights of the duties, it's a right of an agent. So right to recover damages. Say for example, if any misconduct, or if the agent acts unfaithfully, or he makes his personal profit, in such cases principal can recover those damages. And obtain account, secret profit, that agent cannot make his own secret profit. So whatever the profit he has been earned without knowledge of the principal, that has to be recovered and the principal is entitled to. And resist the agent's claim for indemnifying. Suppose if any personal liability done by the agent, in such cases principal not himself is personally liable, then he will be relieved from that liability. Similarly, duties, indemnify the agent for all lawful acts, then against the consequence of act done in good faith. Even though loss is caused to the principal, but agent acts in good faith, lawfully, in such cases, principal must indemnify the agent. Then indemnify for injury caused of principal neglect as the rights of the surety, to pay the agent the commission or other remuneration agreed upon. So whatever the agreed percentage or commission, that must be paid by the principal to the agent. Then lastly, when a termination or when a agency will come to an end. So what are the various ways of termination of agency? One is revocation by the principal. Suppose if the agent is acted misconducted something, or if the act done without authority or beyond authority, in such cases a principal can revoke the agency. It may be by express or implied, by issuing a notice to the agency, by revoking. Suppose if it is in agency for a one transaction, that agency cannot be revoked. But it is for a continuous agency, agency can be revoked at any time. Fixed period. Suppose if agent is appointed for do a particular transaction or a particular act. So after the completion of that particular transaction or act, that agency come to an end. And the performance of a specified purpose. If any agency is created for do a particular purpose, say for example, only for the selling of a house or only for a buying of a house. Once the purpose is served, agency comes to an end. By insanity or death of the principal as well as the agent. Because this is also a special type of contract, only personal liability of the principal and the agent is there. So death or the insolvency of the principal as well as the agent, that relieves the agent or the principal. And lastly, by remuneration of agency, that renunciation of agency. Renunciation means coming out of the contract of agency. That means that agent is no more like to be continue as an agent. That is nothing but the renunciation. So whenever the agent renunciate his agency time, then it is termination of agency. These are all the things with respect to contract of agency.